Good afternoon. We'll get going. Meeting of the Judiciary Non-Civil Committee. Let me recognize Judge Tom Campbell, who's our Superior Court Judge of the Week. Judge Campbell, are you in the room here? Oh, okay. Thank you. We're going to take 897. We're going to postpone that until our meeting on Friday. A notice has just gone out, and we'll go ahead and update an agenda probably after this meeting, or actually tomorrow. But 897 will be moved to our Friday morning meeting. That meeting will begin at 9:30 on Friday morning. 9:30. We'll start off this afternoon with House Bill 1153. Representative Levitas had this bill. I know that there was going to be a minor change to it. You should have a substitute in your folder. Let's just go ahead and make sure we have that, and it's the proper LC number. It's LC 294278S. And Representative Levitas, if you could just give us a quick snapshot of it again, and then whatever changes have been made between then and now, and whatever. I know that there have been some carve-outs and exemptions contemplated and included. If you could speak to those specifically, we'd appreciate it.
Thank you, Mr. Chairman. Before I do, if I may take just a minute, I do want to offer some thanks, actually a lot of thanks, to a group of folks that met for several hours on Monday. Solicitor Fortson, Chuck Spahas, Kim Schwartz, Claudine Wilkins, as well as representatives of the folks who are involved with hunting and fishing issues, and they really rolled up their sleeves and spent a long time trying to do the best we could to reach agreement. I believe this represents about as close as we're ever going to get to agreement, but I do appreciate their hard work. It really made my job a lot easier in trying to bring something back before the committee that made sense. Mr. Chairman, as you will recall, we had a lot of questions raised about the issue of neglect. There were some issues raised about dog training. There were some issues raised about the issue of willful neglect. And what I bring back before the committee really tries to put some more teeth into it. There was some concern, especially I believe from Representative Hatfield and some from Representative Abrams, over the meaning of neglect. So what we tried to do in lines 21 through 23 is put some more teeth into what neglect actually means. And you will see that it means failure to provide necessary food, but that is modified again by such as prevent starvation or dehydration, and again with shelter, necessary shelter and ventilation to the extent that the health of the animal is endangered. There were some questions about, well, am I going to have to leave the air conditioning running on in my car? Again, this is really you're talking about where the animal's health is actually endangered, not just whether they're uncomfortable or even sort of ordinary mild discomfort. On line 25, we have changed the definition just to add causes death or unjustifiable physical pain or suffering to any animal by an act, and there will be one very minor technical amendment I will have here, having care or control of an animal causes death or unjustifiable physical pain or suffering to such animal by an act. After the word animal and before causes, I would ask the committee to accept an amendment, just placing a comma there. This really deals with the issue that Representative Lunsford got at. If I feed a dog biscuit, does that mean that I'm responsible for the care? And here, actually, we're going to have to change that. This says care or control. It should actually read care and control. And the point of that was that you really have to exercise control over the animal, meaning that you have to be able to restrict its movement. So if an animal walks onto your property and you put out a bowl of food, you may be providing care, but you're not providing control over the animal. This is not a change, but line 42 goes to the torture issue, that if somebody knowingly tortures an animal by infliction of or subjection to severe or prolonged physical pain, or causes death, as we already have in paragraph 1. The only other change of significance, there was a specific concern about training of hunting dogs, so we included on lines 60 to 61, nor shall this code section be construed as prohibiting training techniques or practices not otherwise specifically prohibited by law. And with that, Mr. Chairman, I will take any questions that members of the committee may have.
Questions for the author about the changes to the sub on 1153. Seeing none, what's the pleasure of the committee?
Move to pass.
Move to pass by Representative Abrams, House Bill 1153, LC 294278S. Is there a second? Second by Mr. Thompson. Any amendments, Mr. Levitas?
Yes, Mr. Chairman. I would like to amend on line 26, in place of the first or, change that to and after the word animal, insert a comma.
Mr. Levitas proposes amendment line 26, having care and control of an animal, comma. Line 26, having care and control of an animal, comma. Is there objection to the amendment? Is there objection? Hearing none, the amendment is adopted. Any further amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentlelady's motion of do pass by substitute. I can see Mr. Setzler through the wall. I can. On the gentlelady's motion of do pass by substitute, HB 1153, LC 294278S by substitute, all in favor say aye.
Aye.
Opposed? The ayes have it, and the motion is adopted.
Thank you, Mr. Chairman.
Like I said. My kids don't believe me. It's true. Yeah, I'm not making this up. House Bill 31, Representative Loudermilk. Similar situation. We passed the bill out in fairly final form. A glitch was found by council. The bill was recommitted from rules to the committee to cure that one little issue, and I'll ask Representative Loudermilk to go ahead and speak to that change.
Yeah, thank you, Mr. Chairman. I asked to have it recommitted here so we could make the change. The major issue we ran into is, we had quite a bit of discussion on if you sent in your notice and had it notarized based on the red light camera citation, which is a civil penalty, that we made it to where it was a misdemeanor offense to make a false statement on a red light camera ticket. However, one of the options to rebut the citation was to appear at court and take a sworn oath, which was in itself defined in code as a felony. So to make it consistent throughout, we just struck that option from challenging the ticket. We took that out to where it'll just be handled via the form. The other thing that we did left the Levitas amendment in from last time.
Can you show us the language on
yes,
that?
Sir.
Just so, thank you.
Yeah, that would be line 94. Where we're striking testifies under oath in an open court or submits, and we're just replacing that with submits to the court a notarized statement. The other thing that we did.
So this is purely by form then?
It is, yes, sir.
Okay.
We also, because we added a funeral procession option, we also added in lines, I believe that's 101 and 102, is if you choose the option that you were part of a funeral procession, you also would just need to write the name or provide the name of the deceased.
Verification.
Yeah, absolutely. And those were the two changes.
Okay. Questions for the author on the changes? Seeing none. Mr. Setzler.
Just wanted to, was prepared to make a motion, Mr. Chairman.
This would be that time.
I'd like to move due pass on HB 31, committee substitute LC 294258S.
Is there's a second by Mr. Franklin? Any amendments? Any further discussion? Mr. Levitas.
Mr. Chairman, I again want to thank Representative Loudermilk for his willingness, hard work, willingness to compromise on this. At the end of the day, I'm reluctantly not going to be able to vote in favor of the bill merely because of the just policy difference over me and Shell, but I commend Representative Loudermilk for the work that he's done on this bill.
It's the kinder, gentler me.
With that opening. Seeing no amendments, seeing no further discussion, all in favor of the gentleman's motion signify by raising your hand. Opposed? And the motion carries.
Thank
It's
you,
adopted.
Mr. Chairman.
Thank you, Representative Loudermill. Moving right along. House Bill 1328, Chairman Lane.
This is an amendment that the prosecuting attorney's counsel will swearing counsel will fix the issue of money getting to.
Mr. Chairman, members of the committee, I bring you House Bill 1328. This bill is a result of a lot of work by a lot of people looking at the fees that are charged in the various superior courts and probate courts and tax commissioners and sheriff's offices around the state. They've been working on this for about 3 years with a group of folks from those different constitutional offices, studying those fees and looking at what needs to be done. They haven't been. Some of these fees haven't been increased in over 20 years. Most of them are over 20 years. The most recent ones that I can recall right now is like 2001, about 10 years ago. Some of them go back to 1965. So they met with some folks from Georgia State and used the inflation rate from the time the last fee was set in these different places, and came up with the new fees based on that inflation rate from the date, which I think the committee has a copy
Let me just
of.
make sure everybody's got the this Excel spreadsheet or whatever this is called. And the significance of the shading are the fees that have been shaded the only ones that are.
No, the fees that are shaded are the ones that have been repealed in a process.
Okay.
There were many fees
All
that
right,
were on
sorry.
the books that didn't need to be there, so they repealed all of those.
Okay.
All the others are the fees as they were increased from the amount that's on the statutes now up and the recommendation in the last column. And then the last column has got the last date that they were amended.
So we've got the current fee amount, we've got the fee amount adjusted for inflation, which is reflected in the legislation, and then the last column is when that fee was last amended.
That's correct.
Okay, I just want to make
That's
sure
correct.
we're all clear on what we have, what it proposes, and then what the last date of
And
the fee was changed, individual fees.
And even with these changes, they do not, of course, pay for the whole service that's provided. There's still some property tax dollars involved to
Sure.
fund those. So.
Questions from the committee for the author? Mr. Levitas.
Thank you, Mr. Chairman, and thank you for bringing this bill. It's my understanding that this particular bill, will not affect state court in DeKalb County, and that local legislation would still be required if the state court of DeKalb County wants to have fee increases.
That's correct.
Okay. Thank you, Mr. Chairman.
I see no other questions. I don't. Mr. Chairman, would you mind pushing that clipboard toward me so I can see if anybody wants to speak to it? Bill Clark represents the Georgia Trial Lawyers Association. Yes, sir.
Thank you, Mr. Chairman, members of the committee. We do not, I'll be very quick, stand right here. We do not oppose this legislation. We believe the counties have put forward a very strong case for the increase in the fees. And we want to do everything we can to help our court system at the county level to be able to perform the services that our citizens need. We ask you to consider two thoughts, not even necessarily as amendments to this bill, but as this fee discussion goes forward. We believe there are considerable cost savings that could be accomplished simply by going from 12-person jury trials to 6-person jury trials in our state courts. The counties have committed to us to look into this over the summer. We believe you can move forward with it this session, but we appreciate their willingness to look at it. But we believe there are significant county savings to be gained by having 6-person juries rather than 12 in the state, not superior courts. It would require a constitutional amendment to do the superior courts. We're not asking you to do that. But that's something that ought to be a part of this discussion, the cost savings that could be generated. The second thought is I represent the plaintiffs' bar. Of the civil plaintiffs and civil defendants, and criminal prosecutors and criminal defendants, we are the only parties, the clients our members represent are the only parties that pay a user fee for the court system. Many states, a number of states, and I'll have the number for you later today, a number of states require civil defendants to pay a filing fee in conjunction with the filing of their answer. That's an additional source of revenue that this legislature ought to look into to help carry the freight, to pay the freight for the efficient running of our courts. If you raised the civil filing fee to $91 for plaintiffs, why not require the same of the defendant? The defense bar, the chamber, the business, those who are likely to be defendants would tell you, well, the plaintiffs have hauled us into court. They should pay the filing fee. We shouldn't have to. Our response to that is your conduct, defendant, is what hauled you into court. You want to have this dispute resolved fairly by a court. You ought to have to pay part of the filing fee. You ought to have to pay a user fee. And we're willing to say that at the end of the case, if the defendant prevails, the plaintiff not only would be responsible for the filing fee that they had to pay as the plaintiff at the beginning of the case, but they would then owe the defendant an equal amount commensurate with whatever the defendant had to pay. Of course, the reverse should be true as well. So both parties in the civil arena, we believe, ought to share fairly in paying the user fee for the courts. And again, I'm not asking you to amend the representative's bill. I am asking you to consider that thought. The first thought about a cost saving, and the second about an additional revenue source that would bring fairness to the filing fees in the civil part of our court system. I'm glad to answer any questions, but appreciate your consideration.
Thank you very much for your testimony, and we appreciate the plaintiff's bar general endorsement of the loser pays. A little levity late in the afternoon.
I missed
Just getting the blood going. Thank you, Mr. Clark, in all seriousness, for your testimony. I see no one else signed up to speak. Back to the committee. What is the pleasure of the committee? There's a move due pass by Representative Levitas, a second by Representative Abrams. Any amendments?
I need to propose an amendment.
Yes, sir.
We don't have an effective date in the legislation, as I just noticed.
Which means it would be July 1, if signed by the governor.
So we don't need to put it in there. Okay.
I think we're okay.
Okay.
Mr. Sessler.
I should have heard this. I'm sure you said this, and I just missed it. It's probably my own fault for that. Is there anything in here that indexes this over time?
No.
So we're just hard coding these things in the statute, and we'll come back in X years and redo it again.
That's the way it is right now.
Should it be that way, or should we index this somehow? You know, index it to GPI, government prices, and round off to the nearest dollar, that kind of thing. My concern is some of our members are sensitive to voting for fee increases like they'd be sensitive to a tax increase. Voters don't want us dipping deeper into their pockets, even for things like court fees. If you ask a lot of the voters, they see it. I don't think they really make distinctions. If we're going to do this, I just think it's presuming on future General Assemblies to want to have to readdress this. Perhaps we could index this somehow, and so we're not facing this again. When you're when you succeed Chairman Ralston as the Speaker of the House in X years, that we're 8 years from now taking this kind of proposition up again and again and again and again and again.
Yeah.
No comment.
We would prefer to leave the bill like it is. That's a good comment. And I thought about that when I was looking through this. That the reason it's sat there for 20 years or more is that we don't like to increase those fees. So it's a good idea, but I like the bill like it is because it's been worked at for a long time to come up with these numbers and everything. Sure. But I agree with you conceptually.
I mean, had it
it's
been
up to the committee, of course, what you mean.
Had it been important enough to me, I would have crafted a well-crafted amendment and gotten with you and the members of the committee. And I've not done that. I would just share that with members of our committee as we contemplate these in the future. It's something we ought to be doing, and I don't think our taxpayers have an issue with us setting fees and then indexing them over time. It's just, so often you see things that are antiquated that go back 30 years that have not been adjusted that we come back for, and it seems like it's something we could do once and then be done with it. So I just offer that to the author, and thanks for the opportunity.
Thank you. We have a motion. We have a second. Are there any amendments? Seeing none, any further discussion? Seeing none on the gentleman's motion of do pass House Bill 1328 LC 294187. All in favor say aye. Aye. Opposed?
No.
Let me go ahead and get a show of hands. All those in favor signify by raising your hand. Opposed? And the motion is adopted.
Thank you,
Thank
Mr.
you,
Chairman.
Chairman Lane.
Thank you, members of the committee.
Thank you. Calling the Vice Chairman to... Okay, they're making some amendments on an amendment to House Bill 1303, but let me recognize the Vice Chairman to go ahead and speak to the bill, and then by the time he's done, you can do it from there. You can do it. It's whatever you're comfortable. Okay. Okay.
Thank you, Mr. Chairman. This is House Bill 1303. I've got a handwritten amendment that I wanted to offer pursuant to some discussions I've had with Georgia Municipal Association, but I'm going to go ahead and address the, while we're waiting on that to get copied, I'm going to go ahead and address the bill. This is a bill that, okay, here we go. Mr. Chairman, can we?
Lee, could you pass those out?
Go ahead.
Thank
yeah.
you.
This is a bill which affects the open meetings law in Georgia. Currently, under the open meetings law, an agency which is set out in the Open and Public Meetings Act, which would include, among other things, county commissions, city commissions, boards, and authorities. They are required to post notice of their regular meetings at the location of their regular meetings and to maintain those in a conspicuous place. This bill really goes to called meetings, though, and that would be anything other than their regular meeting. And if you'll look, direct your attention to line 15, subsection 2 of the bill. Under current law, they're required to give due notice of a meeting that's held at a time or place other than a regular meeting. And due notice under current law is defined as giving 24 hours posted notice at the meeting, at their location of regular meetings, and then giving a written or oral notice at least 24 hours in advance to the legal organ or a comparable newspaper in that county. Now, there is nothing in current law that requires that the legal organ publish the notice. There's nothing that requires anything other than just someone from, say, your county commission or city commission pick up the phone and call and say, hey, we're having a meeting in 24 hours, just letting you all know. And so consequently, there are occasions where called meetings are held and nothing has ever been printed in the newspaper to let the citizens know who would be interested and concerned about an issue that may come up in a called meeting, to let them know that the meeting is going to be held and let them be able to come and participate if that is permissible in their jurisdiction. There is an exception in current law for counties where the legal organ is published less often than 4 times weekly, and that would be that they will do the 24-hour posting at the place of regular meetings, and upon written request from local broadcast or print media, that they would give notice by telephone or fax to the media outlet at least 24 hours in advance. There is also a provision for when special circumstances occur, and those are declared by an agency, that the agency may hold a meeting with less than 24 hours notice by simply posting the notice and giving notice of the subjects expected to be taken up at the meeting. And then again, I believe there's a provision in that requiring notice to the legal organ. The problem, though, that we're really dealing with is there's nothing in this open meetings law that requires publication. And so what House Bill 1303 is designed to do is to require that not just the notice to a legal organ, but requiring that there be a publication. And so going back to subsection D1, beginning on line 9, we're not changing anything about our regular meetings. Regular meetings would still be subject to the same requirements, but starting on line 15, subsection 2, the change would be that in most counties, you're going to have a requirement that they post 24 hours in advance at the place of regular meetings, and that there be a 24-hour in advance published notice in the legal organ where notices of sheriff's sales are held or placed in the county, or in a comparable newspaper. There is you may have gotten the handout now where I have. We have it. Okay, some proposed amendments. Beginning at line 22, based on my conversations with GMA, they've indicated that, again, there's still concerns about smaller counties that have circulation where their publication is less often than or it's only weekly. And in those situations, we reached an agreement that basically they would have the option of not only posting it at the meeting site, but they would have the option of either posting in the newspaper or posting on the website if that locality has a website available. And so that is what the First Amendment there addresses. Going on to lines beginning at line 27 on page 2, there is a provision that I've crafted here so that an agency can declare an emergency, and if they so declare an emergency, then they can hold a meeting with less than 24 hours notice, provided that they post a written notice at the location of their regular meetings for at least 8 hours, and then give a written or oral notice to the legal organ of the county. And as you'll see on line 34, it says, in which event the reason for holding the meeting within 24 hours and the nature of the notice shall be recorded in the minutes. In line 39, subsection 3, provides that an agency's declaration of an emergency shall be reviewable by a superior court pursuant to Code Section 50-14-5. And what that's all about is that if it's designed to make sure that an agency doesn't declare an emergency just merely as a sham, that there be some actual urgent business that needs to be taken up. And purposely, we have not defined the term emergency because we want to give those agencies some flexibility to be able to hold a meeting, but we do want to have some constraints on them not to merely just declare an emergency in any situation, just merely to flout the law and to avoid notifying citizens. So what that means is, I had the question, well, does that mean that every time that an emergency is declared, it has to be reviewed by a court? No. That only means that if someone raises an objection and files a lawsuit and claims that the Open Meetings Act has been violated, then the Superior Court could review whether or not there was any actual emergency which necessitated the meeting being held with less than 24 hours notice. Finally, in subsection 4, beginning at line 41, and this is going to be covered again by the proposed amendment, which I have kind of scribbled out quickly. Do you have a copy, Jill, of that? Okay. So if Legislative Council has any suggestions on language, I'm certainly open to that. But this is going to provide that when a meeting is held pursuant to a declaration of an emergency, that the presiding officer for the meeting would execute an affidavit under oath specifying how due notice was given, and that affidavit would be attached to the minutes of the meeting. So, in summary, this is a bill that's just about transparency. It's about making sure that our citizens in Georgia have a right to know, or that they do know, when a meeting is going to be held, and have the opportunity to be there or to participate in it as applicable. I may get some may have a question. Well, why is this bill needed? Well, in my experience, the bill is needed because right now there's too many instances where called meetings are held, and very significant things end up being decided in called meetings. And very often you'll find that there's never any notice at all published in advance or in any way given so that the public can be there for the called meetings. We had just to give a little bit of anecdotal evidence, we had a called meeting that took place in my county, in Ware County, at the end of the term of some county commissioners back in December of 2004. And as a result of that called meeting, which citizens did not have the opportunity to participate, there was a decision made to lease out some landfill property, which had never been opened, but was owned. It was and is owned by the county, to an out-of-state firm from Jacksonville, Florida, which intended to open up that property and bring in all kinds of materials, including fly ash and a lot of other things that people in our county objected to. And when things like that happen, it highlights the need to make sure that people have the opportunity to oversee what their government's doing. And so I think that what I have crafted here is it's a little bit different requirement than we have now, but it's certainly not anything that's onerous in terms of the local governments or local authorities complying with, to give people a chance to participate in the process, to know what's going on in their local governments and state government, and to be able to be present if they choose to. Thank you, Mr. Chairman.
Yes, sir. Questions from the committee, Mr. Franklin.
Thank you. I commend your efforts on this, and I like the fact that in your first amendment on line 22, you've added that second provision of posting a notice on the homepage of the website. As you know, more and more people are not reading the paper; they're going online,
right? And
so therefore they're not subscribing to a paper at all. And if I lived in Fulton County, I believe the legal organ isn't even the AJC; it's that lawyer newspaper.
Fulton County Daily Report.
Well, I didn't want to mention that, but it's a normal citizen would not be subscribing to that, and if they wanted to know what their government was doing, they would have to pay a pretty hefty subscription rate,
right,
even to have access to that to that online. And is there a way that we could, at least on right before the number 2, put "and" posting on the homepage? Would you be agreeable to that?
Right before
the number 2 on the third from the bottom.
Well, the only reason that we do that as an "or" is because
in case they don't have one.
If they have a legal organ that's only published once a week, and they want to hold a meeting within 24 hours, then they couldn't. If they had missed that week's publication, they'd have to wait a week to do it. Right. If you put "and."
Right,
this would give them the option of putting it on the website, and that would satisfy the notice requirement.
Right. Where I'm trying to get, and I, that's fine. What I'm trying to get is that all meeting notices need to be on the website, and I don't know exactly how to put that so that if I'm in Fulton County, if I don't want to have to subscribe to the Fulton County Daily Report,
right,
I could still go online and see a meeting notice, because that would be required.
I would be all for that.
And I'm not certain exactly how to put that in an amendment. It might already be in the code. Jill looks like she's about to chime in.
Mm-hmm.
Now, I will say, Representative Franklin, that in my discussion with GMA, I don't think that all cities and all counties have a website. So that
Right,
might
so
be
we need to say if there is one, or however we say that. But my main concern is to truly open it up, and where someone doesn't have to go to the library to look at or subscribe to a legal organ.
Right.
They can just go online, and where it's more user friendly and more open for real citizens, not just those who are in the practice of law looking out for their client's interests.
Mr. Thompson.
Thank you.
Mr. Chairman, and thank you, Mr. Hatfield. I think these are good, or Representative Hatfield, these are good. Trying to open up the notice provisions are good. As a person who attends a lot of city council meetings and tries to help make sure they get noticed properly, I have a little bit of concern that I actually think I agree that perhaps putting it on the website is going to be giving people more notice in many ways than putting it in the newspaper. I'm not sure how many people ever notice a meeting because it's published in the newspaper, particularly when you're publishing it 24 hours in advance. I'm not sure that we would actually think that people go out and actually read through their newspaper looking for the public notice of meetings, as opposed to looking at a bulletin board at the city hall or looking at a website. And I just wonder, I mean, I'm in Gwinnett County, which is a fairly large county, certainly has a daily paper, but it's a daily paper that publishes 6 days a week. So on Mondays they don't publish. So if you were trying to have a meeting on Tuesday, right now they can notice it sometime on Monday. And every time, most of the cities I work with, they actually fax it to the newspaper and keep a record of that and give notice of it. It's up to the paper whether they print it or not. I guess a couple things. Number one, are we concerned about this going to obviously cost the cities every time, or counties or authorities or whoever calls this, it's going to cost them to publish a notice every time they call a meeting. And then number two, do we actually think it's going to notice that many more people that are going to know about the meeting?
Well, I will answer those two concerns this way. Number one, as far as the cost, I think that it depends on the locality. I think that you'll probably find that there will be some newspapers that would probably publish that as a courtesy to the local government. Now, I'm not speaking for newspapers, but certainly there may be some cost involved in that. But I think when you weigh that cost against the right of the public to know, in my mind, the few dollars it's going to cost to put a notice in there is warranted. Secondly, though, as far as how many people, I mean, how are you going to otherwise give notice to the public? You've got to make some attempts. I think that what Representative Franklin was saying is a good thought, that if they have a website, there ought to be a notice there, and there shouldn't be any real cost associated if they've already got a website with putting that on there. But ultimately, there's still a lot of people, depending on where you live, that turn to the local newspaper for their news. And I know in my city, in Waycross, people do pay attention to what's in the newspaper. And we have a daily newspaper there. It's 6 days a week. They're not on Sunday, but 6 days a week. And people do pay attention to what's on there. Our newspaper is also online. You can have this online subscription and see the entire paper there. And so certainly it's they're capable of reaching the populace, but I don't know that you can just go with one method that's going to really have a effect of reaching, the masses of people. I think that if there's a couple of ways that we can do this, that we should, and current law already prescribes the posting at the place of regular meetings. And I don't think what we're asking here of local governments is asking too much.
And Mr. Chairman, if I might follow up, and I appreciate that. I do think the website would be a good idea, and I think probably most cities of any size who have a website, that's probably a fairly regular thing that they do anyway. So I would suggest that's a good process. I guess my other comment would be, is this once again us asking us local governments to do things that we don't do. I'm here at this meeting, having not seen this 24 hours in advance, voting on something that's going to affect folks, and are we going to ask our local government
Doing
to
the
do
best
that?
I can. Right?
No offense. It's just, once again, are we asking local governments to do something that we don't do ourselves?
Well, I wouldn't say that we don't do that ourselves. I mean, I know that we've had notice of this meeting out for more than 24 hours, and that this bill was on that notice. And so,
Of course, we're all on constructive notice the second that a bill goes into the hopper, is read for the first time and read to a committee.
right.
If you want to, stretch it to that now, is that a reasonable thing? Maybe, maybe not. But there's notice, and then there's notice, constructive and otherwise.
Mr. Chairman, I'd have to say that I get that question a lot about local versus state issues, and I think that the General Assembly goes out of its way to make sure that people have the opportunity to be informed of what's going on here, right down to watching the streaming video online. I mean, how much better can you get than that? So what I think this minimal requirement that we'd be asking of local governments is just that. It's minimal.
Mr. Evers.
Thank you, Mr. Chairman. Chairman Hatfield, thank you so much. As Representative Thompson alluded to earlier, I too represent one of those small cities, and being vice mayor, and our city got caught up in this when we had an unfortunate incident to take place in Snellville when a billboard collapsed and 3 people lost their lives. We had to call an emergency meeting, and like he stated, our paper only comes out on Tuesday through Sunday, not on Monday, and the incident took place late Monday afternoon. Right. So we did post a notice. What other emergency incidents can you think of that will arise that will be covered?
Certainly that
would
be.
Because my concern is that I don't want cities to state that they have an emergency just to get around posting of the notices to qualify for having a meeting and not notifying the citizen.
Well, I think emergencies could come in various forms, and I wanted to leave some flexibility for the localities, and that's why we didn't define emergency in specific terms. But I would say, if a local government or an authority is involved in let's say they're involved in a lawsuit, and there's a settlement offer that's made, or that there's some aspect of the litigation that needs to be tended to, and a lawyer needs some instructions on a pretty quick basis, that might be an emergency. If you had a situation come up with some personnel of a city or county that maybe for one reason or another might need to be dismissed right away, that might be an emergency. I think that you could sit here and think about a lot of different examples of things that would be emergencies, but I'm willing to, or at least personally, I'm willing to throw this out there and trust that local governments are going to be responsible and not declare each and every time that they just want to get around the statute and declare an emergency, which is not in good faith. And ultimately, that's why that provision's in there about Superior Court review. Okay. That while I don't think that there's going to be many instances where a Superior Court would overturn that finding by the local government of an emergency, yes, that at least they know that threat is out there, so they better act in good faith.
Deterrent. Right. Thank you for your response on the legislation.
Thank you.
Mr. Sessler.
Thank you, Mr. Chairman. I want to make sure I understand the state of the existing law. It might serve as an impetus for some to support this. As I read the law, it says, and I just need you to speak to this, and perhaps those that practice municipal law can help provide clarification. As I read it, the requirement is to written or oral notice to the legal organ in which let me read. Written or oral notice at least 24 hours in advance of the meeting to the legal organ, which means that, for example, in Cobb County, our legal organ is the Marietta Daily Journal. So if we've got a meeting on Wednesday, by Tuesday I would need to make notice to them. That doesn't require them to put it in the paper on Wednesday morning.
That's right.
So the state of the law is my burden is satisfied to make notification to the public. If I simply get it to the paper and designate and can document that, then we're done. Whether or not it's published or not, whether or not it's and that's not to impugn my paper or any paper, but it's just the issue of you've checked the block if you've simply delivered the message.
That's right.
And recognizing that all the complexities of running newspapers, that can be a hard thing to do, perhaps.
And I will go a step further, and I don't say this to malign any newspaper, but I do know that there are instances where you have, in certain localities, you have cozy relationships that develop between newspapers and local governments. And sometimes they're not cozy, but I mean sometimes they are. And sure, they might pick up the phone and call up the newspaper and say, "Hey, we're going to have a called meeting, 24 hours hence, just letting you know, but we're not really that crazy about it going in the paper." Well, they've satisfied the requirements of the law to notify the newspaper, but if the newspaper chooses then, to follow the suggestion of the local government and not print it, then there's no remedy. There's no violation of the law.
Well, man, I can tell you, our newspaper certainly does a great job of holding our local governments accountable. If there's any question whether that's the case, I think you could subscribe for 5 days and see that.
Right.
But I do think that the concern I've got in the existing state of the law is that it's a sort of a requirement that can be satisfied bureaucratically. I've delivered it. I've checked the block. It's not what I would call a performance-based thing. If you delivered the message 24 hours in advance, versus if you ensured that notification's been given 24 hours in advance, versus if I simply posted notice. So I think that's the core of this, and it's for that I do plan to support it. A question on the amendment to Representative Franklin's concern. And this is really for purposes of clarification. The first set of conditions, again, I'm on the line 22 amendment. Written notice at least 24 hours at the place of regular meetings and publication of written notice. I'm reading this to say that you've got to demonstrate that it's published 24 hours in advance in the legal organ, not just delivered 24 hours in advance.
That's correct. That's the rule for those counties that have a legal organ that is published more than once a week.
Right.
If it's just published once a week, then they would have to post it at the regular meeting site 24 hours in advance, and they would either have to do one of the following two. Either they'd have to make sure it got in the newspaper 24 hours in advance, or get it on their website 24 hours in advance.
I see. Okay, I wasn't following the construction. I thought the 24 hours at the meeting site was.
That's going to be required. The 24 hours at the meeting site is going to be required for any meeting.
Understand how it's constructed now. Okay,
Right.
Gotcha.
Okay. Thank you. I see no further questions, and there are no witnesses signed up to speak. With that, let me ask counsel if she had the opportunity to take a look at the amendment and, from a structural standpoint, comfortable?
Yeah, just as not taking into account Representative Franklin's issue, we would just, because there's already numbers used, the number 1 would need to be changed to a capital A, and number 2 would need to change to a capital B, and I would change that to such.
Okay. In the event amendments are these amendments are adopted, any objection to council making the relettering and renumbering is appropriate? Hearing none. With that, what's the pleasure of the committee, Mr. Franklin?
Move do pass.
Second.
There is a motion of due pass by Representative Franklin of House Bill 1303. LC 294223. Are there, and there's a second by Mr. Setzler. Are there any amendments? Mr. Franklin?
Okay, I've got an amendment to the Hatfield amendment. Do we need to offer the Hatfield amendment first?
Probably. Let's go, Mr. Hatfield. You can go ahead and offer an amendment.
Okay. Well, Mr. Chairman, I would offer what's been pre-printed as the handwritten amendment. Should that be offered as 2 amendments or just 1? Well, just offer that as 1 amendment.
Okay. Is there any objection to the amendment?
Do we need to amend it?
I guess, yeah, if we're going to go ahead and do an amendment to an amendment. Mr. Franklin.
At the end of the first grouping, where the last line of the first group says in advance of the meeting period, change that period to a semicolon, and I'll try to read slow. Provided further that if the agency has a website, comma, then the agency shall post a written notice on the home page of the agency website for at least 24 hours in advance of the meeting, in addition to any requirement to publish notice in the legal organ. Period.
I think I'd be a little more comfortable if we had that printed.
Yes. Can we print? It's a good thing it's your writing and not mine. Wouldn't be able to read it. And you're a lawyer.
Yeah, whatever.
No, you're just a chemical salesman, I know.
Right. When I was a lawyer, I had much worse handwriting.
Across the internet.
I think he's saying, even if you have a website, that for any of these called meetings, that if you've got a website, you have to put it up on your website.
Absolutely.
Mhm.
Can I inquire? I just wanted to inquire upon the lieutenant gentleman's amendment.
The intent of the amendment, if I may, is that if the agency has a website, then regardless of legal organ, they have to put it on the homepage of the website. That's pretty much it.
Going to the amendment, which I don't object to, it appears to me that we're only requiring posting the way it's written now, if you're in a place where you only have a publication once a week, whereas you're not requiring it up in the other paragraph where you may want to require it as well.
Well, that's why I've got it provided further, so that would apply.
But I don't think that's the place.
But that's in paragraph 2. That's what I'm saying. And then when you get to the next, you get to the however, if you only have. So it would seem to me now that if you have a daily publication, you're required to, the way this is written currently, you'd be required to publish it in the paper.
Let's do this.
Do you want to give us a little bit of time to work on that?
I think so. We're coming back Friday morning. The gentleman's going to have a bill on Friday morning anyway. Let's do this. Let's get it nice and clean and printed. Give council an opportunity. We'll go ahead and fashion it in the form of a new substitute, of a committee substitute, and that way we can get it out the door.
That's right.
Just go right to a motion. Just an explanation of the amendment. We'll go to the. If y'all want to get together, and if there's no objection to the amendment, we can just go ahead and consolidate it into one clean substitute,
Right.
And then we'll take it up first, go to the change, go to a motion, and be done.
I think we understand
Okay.
what he's trying
Let's
to
do that. We'll do that Friday morning then. Okay. Yeah, Mr. Franklin, if you would provide Ms. Travis with what it is that you've got. Okay.
Copies going around anyway.
Fair enough.
We'll just suspend action on this.
Yeah,
right
we'll
now.
suspend action. We'll go and take it up in the context of a committee substitute Friday morning at 9:30.
Thank you, Mr. Chair.
Okay, not a problem. Thank you, Mr. Vice Chair. Mr. Lunsford, are you ready to go? Okay.
Mr. Chairman, would you permit? I'm going to say the other chair, the last person that year didn't fare so well. So I'm just going to save it for Mr. Speaker.
Well, I think it was a good conversation. We'll get it done.
Thank you, Mr. Chairman and members of the committee. I bring before you today House Bill 1133. I brought with me today Solicitor Chuck Spahos to explain it. It has to do with pretrial intervention. And with that, Mr. Chairman, if you don't mind, I'll let Mr. Spahos explain the bill, because he has been negotiating with Representative Abrams and Ms. Benefield on some concerns they had when it came out of subcommittee, and I think they have rectified all their concerns. But
Okay.
I'm not privy to the conversation.
We're looking at, and this came out of which subcommittee?
The Setzler subcommittee, Mr. Chairman.
Mr. Chairman, do you want to go ahead and give Chairman Sutzler, do you want to go ahead and give a report on that, or you just want to go to Mr. Spahos? It's up to you. Okay, Mr. Spahos and Mr. Lunsford, we're looking at the committee substitute for HB 1133, LC 4237S, as in Sam. Mr. Spehouse, welcome.
Thank you, Mr. Chairman. I'll defer to how you want to proceed. We've agreed to substitute. It may be easier and delay some debate if we start out by saying what we want to draw back to. Or I can go through it like it is and then explain what we're going to do.
I have a strong interest not only in delaying debate, but abridging debate, if at all possible. So if you could, whatever clarification needs to be, that we'll go ahead and take away that possibility.
Okay.
While certainly not taking away, completely, in all seriousness, that would be helpful just for purposes of time and the other bills on the agenda.
Okay. Then that being said, working off of LC 294237S, where there is now language inserted on line 18 that runs through 21, that inserted language would be removed. The rest of section 1 would remain as presented in this version.
All right. So what we have here, 4237S, is
this is what came out of subcommittee.
Okay.
But, based on negotiations throughout the day and the agreement of all the parties, this will simplify it if we go ahead and.
Do we have another clean substitute, or we do not?
We're not able to get that done in time for the committee meeting.
So what you propose to do is to strike the added language beginning with the words prosecuting on line 18 and ending with the word state on line 21. Is that correct?
That's correct. Yes,
okay.
sir.
Please continue.
The remainder of section 1 would stay intact as you see in this version.
Okay.
Section 2 and Section 3 would be removed completely. And then Section 4 would just be renumbered to Section 2.
We simplified the bill, Mr. Chairman.
Boy, you sure did. So tell me what this bill actually does now.
Not much.
What this bill actually does, Mr. Chairman, is if there is a pretrial intervention and diversion program which is authorized by statute set up by a prosecuting attorney in a circuit, be it the DA or the Solicitor General, the fee that was set when this was originally written, which was many moons ago.
When was that?
I had that at one time.
Around?
I believe 98, 97.
Okay, but more than 10 years ago.
Yes, sir.
Okay.
The fee was set then at $300. What this current version would do is expand it up to $1,000, which is, of course, the amount of money that could be charged if the person was actually convicted of the crime. Keeping in mind, these programs are about after a case generally has been accused or formally charged, and this is a withholding of adjudication. So instead of a defendant being found guilty or having to plead guilty, this allows the various issues to be addressed, counseling, community service, other things, without a resulting conviction. So what this simply does is let us get closer to charging a defendant has been able to avail themselves of this program and not can be convicted, allow them to pay what they would have paid at least had they been convicted.
So the bottom line is that you're raising the ceiling from 300 to 1,000. Pretrial diversion is a prosecutor-driven.
That's correct.
Phenomenon. It's a prosecutor-driven program.
That's right.
And the bottom line is that you could go the fee waiver, of course. That waiverability also rests with the prosecutor as well. Correct.
That's correct. These programs are generally administered without the court's involvement.
Right.
But again, most of the time, result in a withholding of adjudication and a dismissal of the case.
Questions for the author? Is everybody clear? We're looking at LC 294237S. Lines, the added language in lines 18 through 21 have been struck. Sections 2 and 3 have been struck. So the only real change is the changing of 300 to 1,000 in line 23, and then the added language on lines 24 and 25.
Yes, sir.
Okay.
The added language on line 24 and 25 was at the request of the subcommittee, Mr. Chairman, to allow the defendant to have time to pay their bill.
Sure. I see no questions. I see no one signed up to speak on the bill. What is the pleasure of the committee? Move to pass by Representative Levitas, second by Representative Hatfield. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Mr. Setzler.
I'm sorry. I just want to make sure, did we get to Mr. Spouse's question, the striking of the language on lines 18 through 21? Has that been adopted by the committee yet?
I think what we're doing that is we're do pass by substitute pursuant to the changes that we've just talked about. Is that our common understanding?
Bill's going to be left basically with lines 22 through 27.
Yeah.
I just want to make sure procedurally that we're.
Yeah, I think we're doing that in the context of a substitute pursuant to the changes that we've just talked about. and renumber, reletter accordingly. There were no amendments. There was no discussion. All those in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed? The motion is adopted.
Thank you, Mr. Chairman.
Thank you, Mr. Lundstrom. I know Representative Parsons was okay. I thought he might have been in Ways and Means. That's why. Okay. Mayor Luke, could you ask Chairman Parsons to come in? He is okay. I thought he was over in Ways and Means. There he is, right there. Okay. All right. I know it. Thank you very much. Yeah, I'll remember that. Chairman Parsons, welcome.
Thank you, Chairman.
I know that House Bill 567, the Crime Victims Bill of Rights, has gone through a lot of work. And to say a lot of work is probably the understatement of the year. And so I think it'd be most appropriate if we could. Let me call on Chairman Ramsey, if he would, to give us a brief history of time on the bill, what's been done, the parties that have been at the table in these discussions, and to give us a snapshot, or to the extent as full a picture as possible, of what the end product looks like at this point. Chairman Ramsey.
And I would also, I think it'd be appropriate as well to have Mr. Lawton join Chairman Parsons at the table. He's been.
That'd be fine.
I would definitely think it'd be appropriate to discuss the process we've engaged in. I don't want to miss anything in terms of describing the product.
Spencer Lawton is with the Prosecuting Attorneys Council and a former district attorney for the Chatham Judicial Circuit.
But the chairman is correct. The subcommittee has spent a tremendous amount of time working through issues that have been raised through the process. We think we've arrived at a product that strikes a balance between ensuring victims of crimes aren't further victimized through the process of prosecuting the accused offender, while also protecting the constitutional rights of the accused, in terms of ensuring that their rights are protected in a way that we certainly don't want to run afoul through language in the statute that jeopardizes the statute by creating something that's unconstitutional. So I think we've done that. The most debate has been around Section 11 of the bill, which would have initially created a process by which a crime victim could have essentially opted out in advance of being attempted to be contacted by the accused attorney. I think we've reached a compromise on that both the defense bar and the prosecutors are happy with, or maybe not happy but can live with. And we've also removed a couple of provisions. In the initial draft of the bill, there was some language in here, provisions in here that I think would have potentially put us in a posture of running afoul of the single subject matter rule. That provision has been removed. Now we're truly about a bill that is focused on the rights of the victim through the process of prosecution and subsequent appeals. We met 4 or 5 times on this, Mr. Chairman. I think our ultimate vote was, I think we were unanimous with the exception of I think Representative Franklin abstained when we actually took the vote. I could be wrong. He may have voted against it, but the rest of the subcommittee made a do-pass recommendation to the full committee. So with that, I think we've arrived at a good product that strikes the right balance, makes some absolutely critical updates to our victims' rights law, while also ensuring that we're not going to be in court. Anybody's going to be in court defending provisions of the statute, jeopardizing its entire the effect of the entire revisions that we're making. So,
Mr. Long, do you have any comments?
Yes, sir. Thank you very much, and members of the committee. For this purpose, in light of the chair's desire to limit debate and extraneous talk.
Well, let me just say, I mean, this is an important bill. It's a very important bill. So, this, as much as we're respectful of the hour, I certainly don't want to muzzle anyone, especially on an important subject matter. If there are questions or concerns that linger, or that may concerns that may linger currently, but perhaps don't warrant action, do warrant action, or don't warrant action, I want to open that up. I don't want to try to abridge that.
I understand perfectly, and I won't feel in any way constrained by the fact that I have determined that there won't be any necessity for me to read page 6 of my prepared remarks. Thank you very much, Mr. Chairman and members. And that description of the committee's work and of our work is, in my opinion, both succinct and accurate. I appreciate the opportunity to have been heard on this throughout, and I really don't have anything to add. I would like the chair and the committee to note that several people are with us here today. Ms. Kelly Wiggins, who is a surviving victim, Ms. Claudia Barnes, who is the widow of Judge Roland Barnes, Cynthia Hagans, representing MAD, and several members of the Crime Victims Advocacy Council, including in particular, Gordon Rondo, who has been with us throughout faithfully and has contributed much to this effort. Other than that, I have nothing to add. There's no point in replowing old ground. We know what we're here for. I think this accomplishes it, and with the committee's indulgence, I'll just stand for questions.
Any questions for Mr. Lawton of the Prosecuting Attorney's Council? Mr. Setzler.
This is to Mr. Lawton and the author. It raised in our last subcommittee meeting a concern about restitution. Or is the circuit being connected with respect to the monies that are being paid? Is it getting down to the victims? There some testimony had been rendered that shared a concern that in spite of the best efforts of this committee and General Assembly in 2005 in passing a stronger restitution law, there was more than $1 million out there. Perhaps as much as $1.5 million of what I call frustrated funds that they've gone up, they just can't find their home. And I'd ask, I believe the Criminal Justice Coordinating Council to get with you and some others to draft some language that might be offered today as an amendment to try to address that issue, to make sure that prosecutors are collecting information from the victims when they're communicating during the process, so that when restitution is finally ordered, that information is in place so that the money can get where it needs to go. We've drafted, in fact, I was provided some language earlier today that I understood was consensus language. Can you speak to whether you were part of that process?
Does the committee have a copy of that? Yeah, we have been a part of the process. I do have a copy of the suggested language of what I imagine is going to now be an amendment, and we have no problem with it at all. It's an important point.
Do we have that?
Glad that it's been brought up.
Should be in your folder. It's AM 290862. Now, there have been some changes. I had counsel take your language and tweak it some to make it what she believed to be a more appropriate fit for how it would live within the bill. I'm certainly open to discuss that. This shouldn't be a hostile amendment. I did want to make you aware.
I understand that perfectly, and I think we're comfortable with it as I see it written here.
Okay. I just want to get your thoughts before I offered it. It was certainly a friendly amendment intended.
No, thank you very much. I appreciate the consideration.
Thank you. Gentlemen, thank you. We've got a couple witnesses, or three more, witnesses signed up to speak. Sandra Michaels with the Georgia Association of Criminal Defense Lawyers. Sandy, you here?
Thank everyone for working on the bill, especially the chairman of the subcommittee. That's all we have to say.
Thank you. Thank you. Ms. Kelly Wiggins, representing the Crime Victims Association as well as the Mothers Against Drunk Driving.
Cynthia Hagan is with Mothers Against Drunk Driving.
Oh, I'm sorry.
Yeah, I just put us down all together.
Okay.
We were respectful of your time and the day and the hour and such, and we would just note we've been here throughout the process in the subcommittee, and we appreciate the work that has been done through that and the amendments to that restitution, and we support that as an organization of CVAC and through MAD and through victims that are here in support of the bill. Thank you.
Thank you. Mr. Rondo, Mr. Gordon Rondo.
Yeah, just briefly, Mr. Chairman. When I was here before the committee in June, I asked a question that I thought was awfully important for you to keep in mind as you evaluate the bill, and that is, are we doing enough to help crime victims recover and heal? And if you believe that, as I did, that we are not doing anywhere nearly enough, and we see HB 567 as a dramatic step forward in aiding and abetting that process. I have been concerned in the last 15 years, as I have worked with victims in other states on statutes of this kind, to be ever mindful of the well-being of crime victims. And this law does the trick. It is a wonderful step forward. And as a victim myself, I can attest to how important this will be to crime victims in Georgia. So I thank you all for your work in this regard. I urge its passage as such. Thank you.
Thank you. All right, that's all I see signed up. We'll go ahead and proceed to a motion. Move to pass by Vice Chairman Hatfield. Well, thank you for pointing that out.
What?
We'll suspend for just a minute.
What happened? Is that for the amendment?
Well, they're making the motion on the bill right now, and then they'll make the motion to amend it if they get somebody else in.
Oh, quorum?
Yeah.
Oh.
I'm hoping to get somebody else that'll be friendly.
I was going to say, did you have to do it that way?
I guess our mics are off, but when it gets this time of session, sometimes you just have to go ahead and take your vote. When we get so close as we were.
Do what?
I say when we get so close as we were like 2 minutes ago, it really.
Yeah.
But hopefully we can get her. I don't know how many more he needs. I thought he just needed one.
What makes a quorum?
I don't know.
Majority.
Every committee sets their own quorum.
Oh, is that right?
We'll continue consideration of House Bill 567. We took a motion of due pass, which was seconded. I did the motion. Motion by Mr. Hatfield, a second by Mr. Setzler. Do we have any amendments, Mr. Setzler?
Mr. Chairman, I'd just like to offer an amendment, AM 290862. Again, it just provides some language that gives some direction to the prosecutors that if restitution's being sought, they're directed to collect information from the victims and a secondary contact for the victim so that the restitution, when it is paid, can actually get to its desired recipient. And that's all this does. Again, it's consensus language we worked on that I think will be a friendly amendment to the author.
Mr. Ramsey.
I have a separate amendment.
Oh, I'm sorry. Any discussion on the Setzler Amendment AM 290862? Is there any objection to the adoption of the amendment? Hearing none, the amendment is adopted. Any further amendments, Mr. Ramsey?
On line 66, Mr. Chairman, rights needs to be right as grammatically. I would offer to strike the S on rights on line 66.
Everyone got that? Counsel, you got that? Okay. Any objection to the Ramsey amendment? Striking the S in the word rights on line 66. Any objection? Without objection, the amendment is adopted. Any further amendments? Seeing none, any further discussion? Seeing none, we'll take that as a motion by substitute for House Bill 567. We'll go ahead and have the motion of due pass by committee substitute, LC 294264S. All in favor signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Chairman Parsons. Thank you to all interested parties. I don't see Representative Pruitt. What we'll do is we'll postpone consideration of Representative Benfield is raising objection. She wants desperately to stay. All right, let's go ahead and hold then. Let's have get Mr. Pruitt here ASAP if he would. Okay. Representative Pruitt.
Thank you, Mr. Chairman, committee. I hope I didn't keep you waiting too long.
No.
To me, this is a, oh, by the way, I'm working off of LC 351717. And most of this first part is a definitions as you go through. The gist of it, the bill is beginning back on the back page on line 40. But basically, in summary, what this bill does, Mr. Chairman and committee, is that it's a common sense bill to me as taxpayers at the present time that anyone is incarcerated through DJJ. At that point in time, we as taxpayers have to pay for all their medical services and medical conditions and whatever they may need out of taxpayers' dollars. And this would allow us, which we cannot do at the present time, to be able to tap into their medical insurance if they have medical insurance. For instance, if a family, you know, if a mother and father's working, they have family coverage, then we would be able to tap into that medical insurance to reimburse the state for any type of services that's needed. Now, when I say reimburse, basically it would be charged to the insurance that they have. It cannot be more than the cost of the normal insurance coverage or whatever the cost is of the services needed. Basically, you would just ask for their insurance information when they came in. It also does allow for them to personally be responsible for some of their medical care, provided they have money to take care of those items. I'll be glad to go with the bill line by line if you'd like, but that's basically what it would try to do, is get the burden off the taxpayer and put it on people who may already have insurance coverage or have the ability to pay for their own care. In the event they do not have insurance or have the ability to pay, then obviously we still as a state are obligated to take care of their needs.
I see exactly where you're going with the intent of it. It makes a lot of sense. Let me ask you some logistical questions. And
sure.
The first thing that I've got a couple of questions on the reimbursement. I mean, the child is going to be insured as part of coverage, assumedly for within their family's coverage. The insurance company has got the family, and let's just use the group example. Family is part of a group coverage. Let's say one of the adults in the family is the named insured. Everybody else is under that umbrella on that policy. The insurance company has the individuals on the insurance card. As a practical matter, wouldn't it be easier if you're going to do this, that you would have the family, the private carrier of the insurance reimbursing the insured, and then the individual reimbursing the state if the state comes out of pocket? In other words, the state expends X number of dollars. Wait a minute, you've got insurance. This really ought to be covered. I'm just looking at the logistical, potential logistical headache on I don't even know if it's a requirement here, but the contemplation, I'm looking at it, the contemplation is to have the insurer reimbursing the state, but the state's not the insurer. The individual or the family is the insurer. I mean, logistically, that might be very messy for the carrier.
I understand that very well. One of the things I'd say is most of the time the agency, the doctor or the hospital, actually files the insurance, so it would go directly to the one that the payment was owed to. In the event that this, I understand exactly what you're saying, you'd have to make the state the payee. Now, I agree with you that would probably be something that would be some hoops that would be too difficult to jump through. However, what's your replication, and if they do not reimburse the state, when you know that they did get payment back from insurance company, I don't know exactly how to address that, but I would hope that in 90% of the cases or 99% of the cases, the entity that was actually providing the service would be paid directly by the insurance company. I'm open for suggestions.
What happens? In other words, you need that information. DJJ would be asking the individual for that information. What if they refuse to give the information?
You're right. one or two things that happen. The way this is written is they would have to provide the information, but also if they go to the doctor or the hospital and say, do you have insurance, the hospital insurance is the one that actually usually receives the information. Now, if they deny to give it or refuse to give it, I don't know what current law is now, but basically we're taking the current law and expanding it, and so whatever is, I guess, legal in current law as far as other information that's required would fall into the same code and same statute, but I don't have an answer to that. Is
Ms. Howell, do you have any?
Is Terry here today?
I'm sorry, who?
I had asked Terry, the lady that wrote this up with Legislative Council, to try to be here. But also, just changing the subject a little bit, I have talked to the commissioner, and he was excited about this opportunity and understood that it may not be a great amount of money, but it is something that's fair to the taxpayers. And we have Amy with us today to support that.
Yeah, I mean, I think we see where you're going. This is one of those bills that's a great idea. The question is, how can you logistically make it work? Ms. Howell, did you want to go ahead and speak to anything that we've, in our dialogue just now? It's up to you if you'd like to.
Just a second what Representative Pruitt said, and that I did speak with the commissioner, and he is very supportive of the bill and the concept to get taxpayers reimbursed.
Mr. Chairman, if I understand, and you've certainly been here a lot longer than I have, but there's no way in the world to plug every hole.
Sure.
But if we can start with an intent that would make some benefit, and if we run into problems, we can deal with it later. But I just beg you, let's get the ball rolling and do the right thing by the taxpayers, and let's make an effort to get this thing out there to see if there's any problems.
Ms. Abrams.
Two questions, Mr. Pruitt, and actually, Mr. Golick, I know an answer. If the carrier denies coverage for some reason, who would be responsible?
The state's still responsible.
Okay, because my concern is then how that liability for payment language, whether or not that's clear enough to indicate that liability would not be transferred to the parents.
You're right.
The custodian.
I read that and I thought, is that good or is that bad? But then I got to thinking, and you helped me with this, and I'm just trying to come at this from a common sense thing, is that if you have a child and you don't have insurance, basically you're still responsible for that child's medical care until they're 18 years old.
Except that often the way you become responsible is that you drop them off at Grady and you default on your bill. I mean, that's the problem. So are we creating the ability for the state to go after a parent for recovery of cost because either they had no coverage or because the carrier denied coverage?
Is there a possibility that you would be in agreement of putting something in here about indigent care would not be required to pay?
Well, I think there's indigent care is one, and I would be amenable to that. The second part of that, though, is essentially these are children in the custody of DJJ. Let's assume there's an injury that exceeds the level of coverage, because often you'll have single parents who have minimal coverage. If it exceeds their limits, who's responsible? Let's assume they get into a fight that leads to some long-term internal damage, and they've got to have excessive coverage. Is it now the obligation, because the parent wasn't in custody of the child at the time, who then assumes that liability, and how do we recover against that? And if you're a parent who's pursued, I guess my issue, I think, and it runs in parallel to the chairman's, I think this is a good idea. I think my concern is that the language doesn't adequately capture how complicated insurance is in Georgia and how complicated liability is. And so, as you've no doubt discovered this week, liability is a very sore subject for this committee. So, how
would you feel about the fact that in order to move this bill forward, that we delete the parent's responsibility and only have the responsibility of the insurance only?
I'd be okay with that, but I'm not sure how people who represent insurance companies would feel about that. But yeah,
well, I mean, if you're paying insurance premium, there's no reason they should deny insurance coverage to someone who's covered.
Except that your coverage, if you buy a single payer, let's assume, if you have to pay for your insurance yourself, there will be limits. So let's say that there's a $100,000 limit on what the insurance company will cover. and let's assume that you are in the custody of DJJ and you suffer an injury that costs $150,000. Your insurance will pay up to $100,000. Who then is liable for the remaining $50,000? It's not the insurance company, because contractually they're not obligated. If we can remove the parents, if we can basically clearly state that it would be the obligation of the state to cover any excess.
Well, if we remove the parent, I think then you've covered just what you just said, just by taking the parent out. Is that adequate? That
is adequate, and I think that would also capture if there's a denial of coverage.
Mr. Speaker, I'm amenative to that if that's something that.
Yeah, I think what we'll end up doing, let's take some questions now. And I think what that'll do is give you and also Ms. Howell sort of an idea of what curing needs to occur in the bill in order to have it move forward.
Thank you.
We're going to be meeting at 9:30 in the morning on Friday. So what we probably end up doing is holding it for now, come up with some clean language that will address those issues with the intent of having a clean substitute.
If we really do have many issues, I understand that. If this is the only issue,
well, we'll see.
Okay, thank you,
Ms. Benfield.
Well, I had a couple of questions, and now I have another based on what Representative Abrams said, and along the lines of what are the new responsibilities of the Department of Juvenile Justice in lieu of these new provisions. If and when the insurance company does deny coverage, are y'all going to be, is the Juvenile Justice Department going to be in the role of appealing those decisions? Because, I mean, I just know my personal experience is they deny everything up front, the insurance companies, and you always have to challenge in order to get certain procedures covered. I'm battling that right now with my daughter's oral surgery, so I know. So are y'all in the position, are y'all going to be in the position of advocating for the coverage when it's denied? Or is that up to the parents to advocate?
That is a very good question. Would you like to respond to that, Amy?
I think as written, we would be collecting the insurance information and submitting it to the insurance company. So if it was denied, then we would be going through that process.
And then the other question I had is, does the Department of Corrections have a similar process where prisoners who are in the system?
It's amazing that you would ask that, because we have an identical bill that just got passed out of committee yesterday that's for Department of Corrections, but it went to insurance, and they passed it out unanimous.
Interesting.
And it's identical, same bill. It just reflects the Department of Corrections and not DJJ.
When you say an identical bill, you're saying this same exact language?
Same language, other than it's Department of Corrections.
That went to insurance?
Yes. I don't know why, but
and I'm not saying
somebody doesn't like me is what I heard, but I'm not sure about it. But I know
it hasn't passed out of insurance yet.
It passed out of committee this morning. I mean yesterday.
What was the bill number? Because I'm on insurance, and
it was in Howard Maxwell's committee.
Oh, out of a subcommittee.
Yes.
Okay, gotcha. Just temporary confusion.
But I knew that if I came before this committee and got it passed, that it's a done deal. So I would,
It's easier said than done. All right. Ms. Howell, did you have any further comments about Ms. Benfield? I'm sorry.
Question.
Okay.
How do you get around HIPAA and privacy issues with access to juveniles' records?
I think that's a great question. Again, I see this as being no different than if you have a child and you could take them to the hospital or the doctor, and that HIPAA information is what it is. If the parents want to, I would have to say probably Ms. Abrams sounds like she may have the answer to the question.
Essentially, well, you have to. I mean, when they're taken into DJJ's custody, they become the custodians, and so HIPAA doesn't apply.
That's better than I could have said it. Thank you. Since I didn't know.
You're doing a good job.
Ms. Travis, let me call on you. Do you see any structural issues that you may want to, if there are any, to point out for us to be aware of?
In subsection B, beginning of line 32, it talks about the officer may obtain, it's not a requirement, but all of the things that the officer might obtain. There's nothing to say what happens if the parent doesn't want to give the information or doesn't respond to the request for information. So that was something.
If you have some language you could add in there that make it mandatory, I don't know what that is, but certainly the indication would be it would be offensive to me if a parent had coverage and would not provide that information. Now, that's something that, again, I was sharing with you earlier, is that I don't know that we can plug every hole, and we may run into some of these problems and may have to come back and revisit. But it's foolish for us to think as taxpayers, if they've got insurance out there and they refuse to give us that information, there ought to be some consequences. But if you've got suggested language, I'd love to hear it.
Well, I think counsel's point is that, I mean, I think she's making the point that in order for it to have its intended effect, it probably needs to be tightened in terms of, there are differences between may and shall. What will be the duty of the parent in that situation to communicate that coverage, and if they don't, what are the consequences of it? And that's a policy matter that I would actually encourage you to think about in terms of how it is that, in order to make the bill better, in order to perfect it and really truly to have its intended effect, I would ask you between now and Friday to go ahead and obviously in consultation with the department to see, all right, well, what do we want to mandate and why? And then what are going to be the consequences of noncompliance? And does that meet, the intended policy goal? And that's something that obviously we can have, because right now, I mean, we see where you're going. I'm just not sure that, right now, under the way it's written,
it's not tight enough.
Well, it's not that it's not tight enough. It's just that there's too many opportunities for nothing to happen.
Right.
It's that, well, they may, get the information, and they may not give, they may ask for the information, and they may not give it to them, in which case we've accomplished nothing.
And again, that changing may to shall is obviously very forceful, but then again, the same consequences. Just because you shall doesn't mean you necessarily may do it if there are no consequences. So I understand that perfectly, and I appreciate that the committee bringing that up.
I mean, they can go ahead and obtain and require and so forth. I think you do want to think about consequences of what if there's, that coverage and that's not communicated. Well, what, as a matter of policy, obviously I would find that offensive as well.
Okay.
But then, without consequences, what teeth does it have? Not as many as we would probably want. That again, I would strongly suggest consulting with the department in terms of, okay, if there are consequences, what should they be? Because I think the department's in the best position to speak to that, given their experience, which, under no duty to go ahead and talk about right now. You just consult on it.
Very good.
It's sort of the it's what's truly doable in that situation from a practical standpoint. What's really doable from a practical standpoint in that situation, Mr. Ramsey?
Actually,
I'm sorry.
He was helping me because my question was already pushed. The last question I would ask that we consider to Representative Benfield's question about HIPAA is making sure that there is language in here that guarantees that the custodians don't waive privacy. They're providing a great deal of information regarding their insurance information, and we want to make sure that they are not being required and that DJJ knows that they don't have access to any other records except those associated specifically with the juvenile.
Does the disclosure of that information, I guess I would ask back, just out of pure ignorance, does the disclosure of that information from the insured to the department constitute any waiver on their part?
And that's the concern that I would have, that we are creating some waiver of privacy rights, and I think it's important that it be very clear on both sides that you're only getting information for the juvenile, and the information that's gained can only be used for that purpose.
And is that, this may go to Ms. Benfield's question from before, but is that governed exclusively by HIPAA, or
HIPAA would have less relevance because HIPAA is about the actual underlying medical information and not the insurance information. Okay. My concern is more one of fraud, or of just having that information floating out there.
Right.
I may need to talk with you after the meeting because I'm not clear exactly what you need for me to do, but I'd be glad to address that.
Mr. Evans.
I had a couple more things. Just a minor thing on line 46. I just don't know enough about how insurance programs work where, like, if my child is insured under my policy, that the department can then go in and tell the insurance company, don't send the check to Jill, send the check to DJJ. I just don't know enough about how those work to know if that language is appropriate for workable.
Is the word covering, and I'm not expecting an answer right now, but is the word covering the proper terminology in this situation?
I certainly will look into that, and I appreciate the question. The reimbursement to the department, again, you know, that's, I don't know how relevant that's going to be, since I do think that most of the time the payment goes directly to the person providing the service and not to the individual. Yeah. Well, I'll tell you what I'm really trying to accomplish here is to have a beginning that where even if we only got 80%, it would be better than what we're getting now, which is 0. And then if there's something we can do to tweak it now or later to tighten it up, but I will look at that, and I appreciate what you're saying, and I don't know how to address it, but I'll get counsel to help me with that.
We'll have it on the agenda. Any further questions?
And it may be that I have to talk with insurance about it, you know, to somebody on insurance.
It probably would be a good idea just to make sure that the law of unintended consequences doesn't kick in either later on in this process or on the other side.
And again, the identical bill did pass the subcommittees, so maybe they have some insight into that. I have not talked to them.
Ms. Benfield.
How does this work if you're on a HMO? And is this like with the Department of Corrections medical team be considered part of the HMO?
I think that's a good question also, but most Department of Corrections have actually contracts with local hospitals and healthcare services where a lot of times are cheaper than HMOs and things like that. And the local doctors and hospitals have separate agreements outside of the norm and would probably even be less expensive.
Okay, I'm not an I never took insurance law in law school, and I never practiced insurance law, but I do know if you are, you know, on an HMO plan and you go out of network, it's more expensive. So so what you're saying is, what happens if you have to go out of network, or there'll be an effort to be made to stay in network?
The way I envisioned it, whatever the insurance company pays, we'll accept. And it just helps out the citizens, taxpayers, ever how much it does. If it's out of network and they pay a lesser amount, then that's what we get. But in most cases, I think you'll find that the contracts that the Department of Corrections has and DJJ have with the local hospitals and doctors is equal to or less than most of these HMOs and things like that. Not always, but sometimes.
Okay.
Okay. I think you've got the issues that, you know, were pointed out. I think they're valid. And if in the interim between now and Friday we need to consult, or if there are any additional questions need to be hammered out in order to get the tightest substitute you can, certainly happy to do that. And
Mr. Chairman, I thank you, and I thank the committee and Ms. Abrams and anyone else, really, Ms. Benefield, anyone else who has any particular concerns. If they'll come directly to me and let's talk about it, I'll be glad to try to. It's just a simple thing I'm trying to do here.
Sure.
I'm not trying to make it complicated, and I'd like to cover as much as I can to get this thing passed through.
All right.
And thank you very much.
Thank you. With that, we are adjourned.